Okay, I'll call the meeting to order. This is the City of San Diego Police Commission on Police Practices ad hoc transition planning committee meeting of July the 29th, 2002. And we have present today myself. I'm Doug Case. I am the chair of the committee and the first vice chair of the commission. We have a commission chair, Brandon Helpert. We have Patrick Anderson, our outreach chair for 3 more days. And we have Diana Dent, also a member of the commission. We have the commission staff, Charmaine Mosley, our interim executive director, Robert Resendez, our complaints coordinator, and Dwayne Bennett, our outside counsel. And we have our consultant with CPS HR firm, Dave Niemeyer. And Nancy Vaughn, a member of the committee, should be joining us shortly. And so with that, we will do a public comment. I don't see any attendees. Did we receive any public comment via email? No. Okay, then we can proceed with the agenda. Why don't you put the agenda up? Okay. And so nothing on updates, nothing new on the budget process. The staffing process, maybe we can find out where we stand in terms of doing the supervising investigator and the community engagement coordinator. And then the next executive search we will be embarking on is the deputy executive director, and we can talk a little bit about that a little bit more when we get to the timeline as to the exact timing of that. And I'm not sure whether David or Charmaine have any updates on the community engagement coordinator or the supervising investigator searches. David, you're up.
I mean, at this point, you know, I don't. The supervising investigator, again, I think we left that where there's a, you know, a draft brochure, and we were kind of waiting for direction on the timeline to proceed. The community engagement coordinator, I think as we get the official go ahead, I think we can start that, but that's where it's at from CPS's point of view.
Okay, so you know, from the commission, we're ready to proceed with the community engagement coordinator as our priority, and then our second priority for executive searches is to continue do the supervising investigator, and then our third priority will be the deputy executive director.
Yeah. I should also say, and I don't know if she's on the call, I don't think she is, but Liz and I were actually going to go through this. We're having a meeting Monday to kind of go through this. So we'll have some more updates after that, but we have made the engagement coordinator the top priority.
Okay. And any more questions for Dave? Okay. And we can put the agenda back up on the screen. And if there's not any more questions for Dave, you know, you're welcome to stay, but we know you're a busy person and a lot of this might not be of interest to you, and so it's up to you.
Okay.
And nothing new on the implementation ordinance. There was some confusion last week, and I forget whether we cleared it up in this meeting or after the meeting, but the questions regarding the meet and confer had to do with our interim standard operating procedures, which are also going through a meet and confer. And they had a simple question for Charmaine regarding who's the custodian of the records. Office space is proceeding. We got a question today, which Brandon and I will answer regarding one of the details of the space configurations. Nothing new on standing rules. Any final things from Patrick on community outreach?
I guess what I will say, it's been a pleasure to do that work. It's really important work, and I'm happy to know that the commission is committed to moving it forward. I have sent to Brandon a list of emails. I didn't count how many, from people who had explicitly asked to be included on CPP emails. And for the other contacts I've made over the last 2 years who never explicitly indicated that, what I offered to do was to send out an email just saying, we need your consent to, say hi to everybody, but also saying, we do need your consent to put you on this list. And so Brandon has generously created a Google Doc to do that, requests the information and explicitly asks for consent. So I think that's the only update from me. This is my last transition committee meeting. I'm going to miss seeing all of you on Fridays. And I came today, Doug, mainly because I have, I didn't look at the agenda in advance. I apologize, but I have notes on on those later sections of the investigation procedures. So I'm hoping is that what we're going to discuss today?
Yes, and so we have two items on the agenda. I don't think we're going to get to the second one. It depends on whether we get through with the first one. And the primary item is the rest of the investigation procedures, because Dwayne is going on vacation for the month of August, so we're going to try to get as much of that done before we can. And then I also sent out to the members of the committee a revised draft, and it is just a draft of our updating our timeline. And if we don't get to that today, we can talk about that next week. And so if you put back up the agenda quickly. And then meetings with the mayor and city council members. Brandon and I talked, and we may have some follow-up correspondence and follow-up meetings with the mayor and city council members, especially since our numbers are continuing to decline, just to give them an update of where we stand. And also to begin talking about the procedure for the hiring process for the permanent executive director. It never really came to a conclusion on that. And so I think that we're going to begin on section 8 of the investigation procedures, and it seems like it was page 36. Why don't you try that and see if that's the right page? If not, we can go up or back. Yes, that's correct. And can you make it a little bit larger? Perfect. Okay. And I unfortunately had left my hard copy at home where I had some notes. I'm not sure whether I had any notes on this section or not. So maybe we can, excuse me, go through it section by section. It says go back up to the okay. There's the complainant, subject officer, executive officer, a member of the commission may request an investigatory hearing for some or all of the allegations of a case. I guess a question I have about that is, I guess it just says request. I mean, so the determination whether there's going to be a hearing would be up to the commission. The subject officer can obviously request it, and I'm assuming the complainant can too, but that it would simply be a request, and then the commission would consider that request. And then if you scroll down a little bit, and here are some of the reasons for having a hearing. There's been an undue lapse of time since the occurrence. There's additional witnesses. And then this would be a hearing after the investigator has submitted his or her report. Yes. So there's additional witnesses or information that was not in the investigative report. There's reason to question the conclusion of the investigative report. There's heightened public attention, and the commission feels that a hearing would advance public confidence, and an appearance in person by the parties would facilitate the fact process. Dwayne, did that come directly from a CLRB?
Yes, a lot of this was based upon the investigative hearing process the CLRB uses. CLRB has indicated to me, at least Paul Parker has indicated they've never had one of these hearings, but it is an option. It's an option where you, and first of all, you'd have to have investigatory powers. So this will be after the implementation ordinance, when the commission will be conducting its own investigations and would have certain questions that fit within that criteria. So what I did was I used the CLRB information as a template, modified the language to fit the CPP and change some of the characteristics in light of what you all do. But that would be the process. So it would be a process that is predicated upon due process. If you had questions about the investigation you received, or you didn't think the investigation covered certain aspects and the commission decided it wanted to take the issue on itself, it could. And this is the typical process that is used by many review boards. For example, retirement boards, a lot of times will have a hearing by a hearing officer, and the hearing officer will make certain findings, and the retirement board can accept the findings or reject the findings or decide just to hear the matter itself. And that's this type of process.
When in the process would the complainant become aware of what the recommendation from the investigator is?
Well, you would let once the investigation is over, the investigator has defined or decided whatever the investigator wants has decided, and the commission has accepted the recommendation of the investigation, then what we would have to do is go back to what the implementation ordinance, whatever it ultimately says in terms of how that information will be conveyed to the complainant, and it will be conveyed in that manner. At this point in time, we really don't know because the ordinance has not been finalized. We don't know exactly what they're going to say, but we would address that in due course. And you'd always let the complainant know that the matter is being investigated by the CPP. The CPP would have to allow or have to make known the investigative processes that it would be using to investigate the complaint. This is what we're going to do. And if the CPP decided to involve itself in this investigative hearing process, you would notify the complainant of that also, once that decision is made.
Okay, and I see Patrick's hand is up.
First, Nancy is in the attendee list, so I think if she could be admitted. So Dwayne, thank you for that. I think a lot of my notes, and I'm switching back to my copy rather than looking at the screen. A lot of the notes that I have here are my questions or suggested changes make sense knowing that this was based on the CURB model. So so this first section is what we're talking about right now. I had a similar, I think it's probably a similar question to Doug. So I like that in that opening clause, a complainant, subject officer, executive officer, member of the commission may request an investigative hearing. I did wonder about the connection of that to number D on the list, the public, if there's heightened public attention.
Mm-hmm.
And I think one question that members of the public might have is can a member of the public make a request to be considered? I generally think, because we're just talking about a request, that as many people, people can make a request and then the commission considers it. I also wanted to point out that a lot of the time we have third-party complaints coming in. And so the current list wouldn't include subjects who didn't make complaints about their own incident, right? But had a community member call it in. And so we do want to make sure that somebody who's the subject of a complaint, even if they didn't call it in themselves, can also make this request. So in that first clause, to make sure we include, I sort of feel like anybody can make the request, and then the commission could consider it. And then just really quickly, the other 2 points I had on this first section, I wonder if we need to spell out explicitly here, I didn't see it anywhere else, where it says when the commission determines. I wonder if we should say when a majority of commissioners vote or something, or just spell out exactly what the mechanism should be to prompt it in terms of a vote. And then I had a similar question about specifics with under point A, undue lapse of time. So if I think that's just an example of when it may be helpful. But I do wonder if we see really intense delays in the cases we get from IA, if there might not be some kind of trigger mechanism. It's a question that occurred to me. I wasn't sure.
Right. So Patrick, just to follow up on that last one, are you talking about trying to better define the terminology of the verbiage undue lapse of time? Because what that does, that's in there, really in the discretion to allow the commission to have certain discretion as to when you do it. So I don't know if you want to force these types of hearings on yourself or further define that, particularly in the situation you're in right now as a commission. But
I agree with you. Yeah, go ahead.
No, so I was going to say in terms of, okay, so you said a bunch of things. Yes, any member of the public could ask for an investigative hearing, but they'd have to do it by involving themselves in the public process. So if some member of the public, for example, were to come and say, I know that so-and-so filed a complaint against the police department, I would ask if the commission consider taking it away from your investigators and doing it through the investigative hearing process, then the commission can always consider it, and a commissioner can decide, or somebody may decide to do it that way, but that's the way they'd have to do it. So just by participating in the public process, coming before the commission under public comment or agenda items, speaking to the issue, and then the commissioner somebody could say, yeah, I think we should do it. And that happens often in city council meetings also, where a member of the public can request a certain type of appeal or something, the council may take it up.
So I wonder then if, given that, if we should just change that opening clause to anyone. So anyone can request, including subjects of a complaint, complainants, and so on.
Yeah, I would not advise that, because you'd have a ton of people comment, people will request investigations without standing. And sometimes, you have to be, and there's one thing as long as I'm here, I'll always caution the board or the commission about third-party complaints, because you have to be careful about them. Yeah, anybody can complain of misconduct, which could trigger an investigation, but the commission, and including the police department, everybody has to be very, very careful about those, because you don't really know the veracity of the complaint that's coming in. And if the complainant does not go on record of making the complaint themselves, we could have a quagmire in our hands. So I think that I would not say anybody. Anybody, the public is more than willing to always participate in the process, and they can request it. But if you set that expectation that anybody can at any point in time request one of these hearings, when you say no, you're going to dissuade people, or you could turn off the public. So, although Patrick, you're right, any member of the public can speak to the process. And so, but yeah, look, if the commission gets into doing investigatory hearings, you're talking about delays in terms of cases and how you're going to handle cases. This would really, really, really slow down, because this process is very, very detailed and cumbersome.
I'm satisfied with that answer. You answered my question. Thank you.
Okay. So anything else on this section? Okay. The next section says that we would identify the scope of what you're going to be discussing in the hearing, and then the hearing would be limited to that. So it could be looking at the entire case, or it could be simply looking at one one small aspect of the case. It could look at one allegation out of many, et cetera. So the scope of the investigation would be identified. A subject officer may admit or enter a response of no contest any time in the process. Okay, and then I guess kind of self-explanatory. So we can move on. Hearings in general. I'll just let people take the time to read the screen rather than me reading it to them.
If I can comment, Chair, the language in red is totally discretionary for you. In CLRB, I think they use, they select a hearing panel. It's not all the commissioners because, you know, it's really too difficult to deal with, but they use, I believe, 3 commissioners. You have a bigger board, you might want 5, you might want 7, you might want 3. I mean, you need to have an odd number, but you have to have a number that you believe you be able to assemble and consistently manage, and a number that you know would be there throughout the process. So that's that. I just suggested 5, but you can change that. You know, I just suggest that you have to have an odd number, or you should have an odd number, whatever that number is.
Okay, I happen to like the number 5. And Patrick, is your hand still up, or is it up again?
No, it's up again. It's up again. I like the number 5 too. And the reason I like it is that our case review teams tend to be 3. And so the nice thing about this is that it makes the case a little broader than the team that initially may have looked at a case, and it brings in other commissioners to chime in. So I liked the idea of having 5. The other comment I have about this section, this is one of those things that's CURB specific. So in cases involving an in-custody death, the whole commission has to sit. I think that's because the sheriff's office oversees the jails and prisons, and so CURB in-custody death is a major issue of concern for CURB. I think we have a different context here, and so I had a question about whether that should stay in, and if it does stay in, well, either way, I also wondered if officer-involved shootings that result in a death should also, or even that didn't result in a death should also be here. But the specificity of in-custody deaths, I think, is specific to CURB and CURB's concerns recently. So I do think we should change that somehow.
Yeah, I would agree if we're going to require that the entire commission participate in the hearing for an in-custody death, that we also include officer-involved shootings.
Would it be officer-involved shootings resulting in death? Or do you all want?
I would say officer-involved shootings generally.
Okay, so just so you all know, and it's perfectly fine. That means that I guess you'd have to analyze how many shoots San Diego PD has if they're just all shootings. I mean, you have to think about, just weigh the resource allocation on you all as a commission. Are you going to be able to assemble or do these for every officer involved shooting? If you have, for example, 25 shoots a year, is that feasible or is it reasonable? I don't know. That's a discretionary call in your case. We can certainly change it just to say that in all cases involving an officer involved shooting, and then I still like the language, and in such other cases as the commission shall decide, the commission will sit as a whole with a minimum of 13 members present. Again, you can change that number if you want, but yeah, I just think that.
Yeah, well, but this section just talks about the number of people that are going to be on the panel, and so I don't envision that every in custody death and every officer involved shooting is going to result in a hearing. This is only if there is a hearing, and
it depends. Well, I need to specify that. So what are you saying? So can you guys just clarify for me exactly what you're saying, because I think my meaning may be different than yours, but please say.
I mean, well, this section here is talking about hearings in general, and it's if I read it correctly, it's saying that if there is a hearing, it'll consist of 5 people, or if it's in a certain category, that it'll be, the entire commission provided that a quorum is present, but it doesn't say, it doesn't, so by adding in custody death or officer involved shooting, it doesn't mean that there's going to be a hearing on each of those. It just means that if there is a hearing, that the hearing body would be the commission as a whole. Does that make sense?
Okay, so yeah, I understand what you're saying. That wasn't my meaning. So that's good. That's good clarification, because that wasn't my meaning. So what I mean, so what this is, what I was trying to convey here is that where you have that specific case, where you have, you know, I'm not saying what CLRB does, but I'm just saying for you all, since the charter really specifies and calls out officer involved shootings and officer involved shooting deaths, that the intent here was in those cases, where you have these hearings, you will do it in this manner. But you know, it could be a mandatory, like what I hear you saying, that you want a mandatory. Is it your intention to have a mandatory investigative hearing?
Oh, no.
No, okay.
So
So
no, and so I'm just clarifying that this
Okay.
that this section says that if there is a hearing on this matter, then this is how the hearing panel would be the entire commission.
Okay.
But no, I am not suggesting that we should
Okay.
have an investigative hearing for each officer involved shooting or in custody death.
Okay, so if there is an investigative hearing, I'm typing as you all are talking. If there is an investigative hearing on an officer involved shooting, then this is the procedure we use. Is that right?
Right. Well, and I'd also include in custody death.
Okay, okay, got you. We do have in custody death also. Okay,
Right.
all right, okay. So what I'm taking is if there is an investigative hearing involving officer involved shooting or in custody death, this is the procedure. Do you still like? The reason I said 13 is it'd be a majority of the commission. Is that still a good number, or do you all want to change that number?
You know, just thinking about the challenges we're currently facing, maybe saying that
Consider the whole with the majority.
what I would say with a minimum of
We currently use
minimum
7.
with the majority of the filled seats. So the minimum
With the majority, with a quorum.
yeah, with the quorum, maybe the quorum
Okay.
present, yeah.
Okay.
I would propose we use the quorum language that we already have now, because I think we have that with a
Right.
minimum of 7. And so I would just copy that exact same thing.
Minimum. So do we want to say a minimum of 7, Brandon? Would that be assuming how many commissioners you have? What do you think? I mean, it's your call.
I think the way, and I'd have to go back and look at it. I think the way we have it, it's a majority of the seated commissioners
Seated commissioners.
with a
That's
minimum
good
of
language.
7.
Okay, with a minimum of 7. Okay, but what if you don't have it? Do you still, you see what I mean? I mean, I can do that. It's just up to you all.
Yeah, I think we selected the 7 just because I'd have to go back and look at my notes. I don't remember exactly why we selected that number 7, but I think the idea was we were hoping to be able to at least have a wider spectrum of community impact, you know, from the people who are representing various aspects of the community. That I think that's how we pulled that 7 number. But like right now, we're going to be down to 11 commissioners. So we could get dangerously close to that 7
Right.
number.
Right.
Yeah,
Should we just say-
but hopefully once we have a full, I mean, once we have a implementation ordinance, so, you know, we won't have this current issue of not being able to fill empty seats. But I do think we need to have a provision that says with a quorum, and we can, and I'm fine with defining quorum as we have it defined in the bylaws. But I just wanted to make sure that we had the flexibility in case our numbers were to you know, be less than a 25, that you know, we would still be able to have a or you know, the ability to have investigative. Well, we'd have the ability, but to not have an unrealistic number. If, you know, say our numbers decreased to 15, getting all 15 members to be getting 13 members to be at a hearing may be a challenge. And so
Right.
if we use the same language that we use for a quorum in the bylaw, I think that is good. So what I may move on, because I want to give Patrick a chance to get his issues raised before we have to complete today. The next is the ration reasons for challenging a commissioner. Let's scroll down this a little bit more so you can look at, so those are the 5 reasons.
This is unique language, but it's in there just like you have in any quasi judicial proceeding to preserve due process. So if you don't have, I know it may sound a little weird, but it's consistent with the way we handle matters in court. And if you believe that there is somebody who's on the commission who has that bias, you know, because it's the due process and it's supposed to be a fair process for the officer as well as the complainant, that's why that language is in it. It's almost like a peremptory challenge for a judge or for a juror.
Then we can scroll down, and this is the procedure for making a challenge. Let's look at that for a second. Go back. Who can make the challenge? Go back. There you are.
It could be either side. And so you typically will have either a complainant or you'll have an officer. And primarily it's going to, you know, most likely it's going to be the officer who's going to make the challenge.
So my only comment here is that, so we have an odd number of people, and if one person is being challenged and the chair approaches that person and says, hey, you're being challenged, do you agree? And the person says no, it says the other members of the panel will be polled. And so there is a potential split there. I just don't know if there's a way to avoid that. That was my only imagining, you know, if something emerges from this.
Right. If it ended up being a tie, it would have to go back to the chair. You have to break it.
To break the vote.
Yeah,
That makes sense.
Got to
So,
break it.
Yeah, well,
Yeah.
I was assuming differently. I was assuming that if somebody is challenged and removed, that they would be replaced. And so if we require 5.
Right. That's correct.
no, that's correct, Doug. I'm saying if you look at the second paragraph at the end of it, if somebody, let's say I'm challenged on a panel of 4 or on a panel of 5, and Brandon comes to me and says, hey, you've been challenged. Do you agree that you might have bias here? And I say, no, I don't have bias. Then it says that Brandon polls the other members of the panel, and there are only 4 people left. And so I'm saying there could be a tie there.
Right.
And Dwayne responded that in that case, the chair would break the vote. And that makes sense to me.
Right. And then reset or install another commissioner. That's on the next page.
Okay, so let's look at the next page then. I want you to go back for a second. Let's give us a chance to read the section. So go back to the beginning of the section here. Okay. Okay, let's scroll down a little bit then. When an incident has been or is highly known to the public, there is nothing that prevents the commission from holding open public hearings to receive community input or comments concerning the incident.
Right. That's my language. And
the commission may consider public
language.
Okay, so they're not. Okay, so you're not saying that they would be part of the hearing. It would just be there would be a process for public comment. Okay.
Correct. If you had a high profile, just take George Floyd. If you had a George Floyd incident, and everybody knows that you're looking at this, and everybody knows that this is of such a high profile, the commission says, no, we need to do it. We need to do an investigatory hearing on this aspect. There's nothing. What I'm saying is that there is nothing that prevents the commission, even though this is a confidential proceeding, there's nothing from preventing you from receiving testimony of people who know something about the incident. You don't have to comment on it. but it's just a part of your information gathering process. You can have a hearing on it. You can hear from anybody, whether it be police or somebody or a complainant. You can receive that and consider that information in the context of your ongoing investigatory hearing. That's what I'm saying.
Okay, then let's go down the authority to compel attendance.
So I have a question
Okay,
about that last answer and also about this section. So yeah, I really love that section, Dwayne, that just explicitly enabling the commission to listen, to hold a public hearing where they hear but don't comment. My question about that is, so later when it says the only evidence that can be used is evidence that's been obtained within the hearing, does there need to be some language that says that may include testimony received at an open hearing, since by definition that testimony would be outside the context of the hearing itself?
Yeah. Okay. So Patrick, yeah, I thought about that in putting this in here, and here's the way you have to respond to it. Evidence or information from the public is not necessarily evidence. Now, it could lead to evidence. It could lead for the commission to do it because it's not sworn testimony. So,
gotcha. Yeah.
You see what I mean? So, but it can lead to it. So it's still a factor. And you don't want to get in the middle of a hearing where people are testifying, under oath, et cetera, and say, well, Miss Jones said this and Miss Jones said this. That discredits what you're saying. But it still is a factor and something the commission can use in a conundrum. And maybe it leads to questioning. Maybe something the person, said leads you to question somebody under oath. Well, is it true? Blah, 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 which leads to evidence. See what I mean?
Gotcha. Yeah, thank you. This is why I love you. I mean, we all love you so much. That completely answers that question.
Thank you.
And then the question about authority. So I just had a question about the legal side of this, because my memory, and I didn't go back and look, is that Measure B says that the commission has the authority to subpoena. And so I'm assuming here that the reason this says the authority of the executive director is that by definition, legally, the executive director is the person who issues the subpoena on behalf of the commission. Is that right?
Yeah, exactly.
Gotcha.
That's
okay.
Exactly right. Got to have one person who signs it.
Gotcha. Thank you.
There you go. Uh-huh.
okay. I want to just drill down a little bit.
This is just a procedure, and this is again a common procedure that's used in arbitrations and hearings.
So I had another question here. I'm so sorry. I just wanted, since this is my last meeting, to get all of my notes on this document. So I'm sorry to be asking so many questions. So in section D at the bottom here, it felt to me like having, so if there's a point where people are still asking questions, this says the chair or presiding member shall determine whether any future questions will be asked. And it felt odd to me that both those people are there, given that a presiding member has been named. And again, just imagining potential situations, I imagined a situation where the presiding member and the chair might disagree on whether questioning is done.
Mhm.
So I wondered if we should just say that the presiding member of the hearing shall determine, or if people thought it should be the chair, or I don't know. But that was a question I had.
Well, the thought there was that somebody who at some point somebody has to call a timeout. You may have to call a timeout, and that could be the presiding member, or it could be the chair, depending on who's there. But that just gives you flexibility. But I could change that as you all deem appropriate.
Well, I mean, is the reason that you have a presiding member or chair maybe that's related to the fact that sometimes there are going to be meetings of the whole.
Yes, and yes, and yeah, and you may have
Oh,
different members, so.
so maybe it's worth spelling that out. So for a typical hearing, the presiding member shall determine. For hearings where the full commission is present, the chair makes that determination.
Yeah, well, and maybe just do the presiding member, because if the chair, if it's a meeting of the whole,
Yeah.
the chair is going to be the presiding member, and perhaps the chair is absent, or the chair has to recuse themselves, and so it could be the vice chair or whatever. So maybe just take out the word or the chair in both of those situations and
Okay,
see it.
okay, it's already done. The presiding member shall determine.
Okay.
Okay, thank you. As you're speaking, I'm making corrections to my copy.
Okay. And then scroll down a little bit more.
And my last couple of questions was just again about this section in F and G that stipulate in F, the investigative hearing panel shall not consider any information not received as part of the investigative hearing. And there's a similar thing in G. So I'm assuming, let's say there's an investigative report that precedes the hearing that's been written before the hearing, or let's say that Internal Affairs has handed over its evidence and we received it before the hearing. All this is saying is that all of that needs to be read into the record as evidence at the hearing itself to make sure it's incorporated, right? It's not barring consideration of that stuff.
Exactly right, Patrick. So what you would do
Okay.
is in a process like this, you would admit that as an exhibit, even if you don't agree with it. You know, even if there is some questions to it, you would admit it as a part of the record. And you'll notice that these investigative hearings have to be transcribed. So there will be a court reporter or somebody there taking that information, and they would list that document as an exhibit. You know, these things can be challenged in court. And so you have to have an official record. So you're exactly right.
Got it. Those were my last questions. Thank you so much, Dwayne.
Okay, and then go on to okay, so this is what happens after the hearing, that the full commission gets the report of the hearing panel. And it goes to the extent afforded by law to each complainant and subject officer. And let's go down to the next page. Okay, and then so the 5 options here are that they can vote to conclude the hearing. They can vote to request additional information. They can vote to conduct further proceedings. They can refer it to a different agency, for example, take an appropriate action, or finally, they can accept the findings of the hearing panel. And record the evidence.
This section indicates that the evidence, it doesn't have to be like, it's not going to be like a courtroom process where we have somebody admits or somebody asks a question, objection, leading, objection, irrelevant, hearsay. There may be a limited amount of hearsay admissible. So that's basically what this is saying. Hearsay is an out of court statement used for the truth of the matter asserted. And in these proceedings, you will have hearsay. The Internal Affairs report is all hearsay. I mean, it's based upon out of court statements that aren't necessarily sworn, et cetera, and they're used to for the truth of the matter asserted. Well, you can admit, or you can use and rely on hearsay in these proceedings and other types of evidence. It's not going to be like a courtroom process. But you do have a right to examine witnesses. You have a right to introduce exhibits, as we just mentioned, to examine and cross-examine witnesses, because it is, or it will be, a quasi-judicial proceeding subject to a legal challenge.
Okay, I'm gonna go back for just a second. So the right to examine or cross-examine witnesses is a right of the panel. It's not a right of the complainant or the subject officer. Is that correct?
Yeah. The subject officer can call witnesses and can cross-examine and examine. So the panel can do it, and or whoever is speaking on behalf of the panel, but the officer can do the same. Yeah, the officer is the one who's being accused. They have a right to call witnesses and cross-examine witnesses, etc.
What about the complainant?
Yeah, the complainant is not necessarily there. I mean, the board is seeking the information on behalf of the complainant. So, from the standpoint of the complainant saying, I want to call in a witness, it would be subject, at some point, if something like that ever happened, it would be subject to the board's discretion, but you have to be real careful with those. So you would be acting as a fact finder to see, you as a board would be acting as a fact finder to ascertain what exactly happened. And so that would be really your purview.
So I originally had Doug's question too, but I think the way I answered that myself, and please tell me if I'm off here, is that because of POBAR laws, the complainant cannot choose to be present for the entire hearing because the material included in the complaint is protected for the officer, right? And so that for that reason, a complainant doesn't have the right to cross-examine everything happening because they can't even be there. Is that true?
Yes, and what would happen would be at some point in time, if the commission said, we really need to hear from the complainant. Keep in mind, it's a closed process. Okay, so you say you brought the complainant in, or you took something in, you would be asking the question. You would be doing it because this is your hearing. It's not the complainant's hearing, and you're not sitting as a judge watching a complainant go after an officer. No, you're doing the hearing. The city charges you, and the charter charges you with that responsibility. So that's your burden. Although you might have a question from for a complainant, you may say, hey, this is what we have, and they may have witnesses or something like that, and you might follow up with those witnesses. But that complainant could, for example, say, officer, I want to know how many times you've beaten people like this in the past. Okay, that's personal, that's privacy information. You can't get that. So Patrick, your question is correct.
Does the officer have the right to compel a complainant to appear?
No, nobody.
So even though
nobody can compel. No, you can't compel the complainant to appear because the complainant has the discretion to file a complaint or withdraw it at any point in time. So the officer could not compel the complainant to appear. What an officer could do is comment on the fact that the complainant did not appear or did not cooperate to mitigate any findings against that officer. So, if somebody files a complaint against me, and then if there's a hearing and the complainant doesn't show up, then for sure you can comment on that and you can use that against that complainant, but you can't make them participate in the process. And the commission can't make them participate in the process. You can make a finding, notwithstanding the fact that a person doesn't participate in the process. And that's going to be the interesting thing when the city implements or whenever it does its ordinance. I mean, when you're investigating these things, I don't know how the city is going to handle whether or not they're going to force officers to participate in this process. I don't know. I don't know if they're going to say you must do it or you have to attend. I'm not sure how they're going to do it. Or if they're going to leave it to the discretion of the department. But that doesn't mean that you are helpless to go ahead and investigate as best you can, with or without the officer's participation. We'll have to see how that shakes out.
So if a complainant is sort of called by the commission and interviewed or questioned as a part of the hearing, the officer or their representative has the right to cross-examine that complainant?
Yes.
Okay.
That's the way I would read it. Yeah, they certainly do, because you have to keep in mind now, the process or the property right that is going to be affected is going to be that of the officer. So, and now the victim or the complainant may have already lost something. They may be in litigation and in lawsuit against the officer or something. But the issue that you're going to be ascertaining is what happens to the officer, or what is the finding that you make of this complaint.
Okay. Then I have a question I have, and maybe it's answered elsewhere, but I don't think I saw it. What is the role of staff in the hearing? I mean, first question is, can the investigator who wrote the investigation report be present, and can they ask questions, and can legal counsel be present? I assume legal counsel can be present and legal counsel can ask questions. Is that?
So Chair, it depends on you all. I mean, for sure, I would assume you definitely want the investigator present. Most of these proceedings, you'll have the investigator present, if for no other reason, just to guide the commission,
Right.
And what we call an investigative officer. You'd also want a lawyer present, somebody, just to make sure the proceeding is appropriate. If there are objections, how to handle those things, and to make sure that you all, have counsel in terms of what is appropriate and what is not appropriate. So both of them will be there. I would not necessarily delegate the responsibility of the investigator to ask questions, although the commission could delegate the responsibility. You could delegate the responsibility to ask questions of an attorney, but in these proceedings, you need to have a couple of things. Number one, if the commission decides to ask its questions through its lawyer and sit there as a jury, it's sort of like a jury. Okay, that's okay. But then you need to have another lawyer there who would sit in adjudication in a neutral position, just to make sure the proceeding is fair on both sides, if that makes any sense.
Okay, yeah.
I mean, you don't want to have too many lawyers, but if otherwise the commission, you would be like a congressional body asking questions yourself. Any commissioner could ask the question, et cetera, and your lawyer could sit there just to make sure the proceeding is fine and goes fine, and stay out of it and just answer legal issues on either side.
So I'm just wondering whether it might be beneficial to have a clause somewhere stating that the commission may invite staff to attend the hearing, including the investigator,
Sure.
the executive director, and general counsel.
Sure, I can add that. And that would be the commission's right for sure.
Right, and I would say including but not limited to, because you may want to have the supervising investigator, or the deputy executive director if the executive director is not available, et cetera. So
okay, got it. I can add that for sure.
okay, then let's move on to we have 3 minutes left. And Patrick, were there any notes that you wanted to
No, I've asked all my questions. Thanks.
okay, and so let's see how far we can get in 3 minutes.
Are you on section 2 where the evidence is now, or have we? Because I can sum
Okay,
that up.
Yeah, we're on the evidence.
Yeah, it's just one more page, I think. We talked about, everything. I can sum it up real quickly for you. Everything is going to be taken under oath. You'll be swearing in witnesses. Irrelevant and unduly repetitive evidence shall be excluded. That's typical. Privileges apply. So you could not ask an officer, for example, what they discussed with their representative or what their lawyer told them, et cetera. You couldn't ask them about marital spousal privileges, or what they discussed with their priest or anything. And here in number 6 may take, I'm not sure that you can answer or see if this answers the question. Each party, any witnesses shall have the right to an attorney or representative of his or her choice present at all times or at any time. I can add the additional language that you suggested right there in terms of staff or commission, et cetera, et cetera. So anybody can have an attorney or representative present. And you can, just like I say, the commission could ask its questions through its lawyer if it wants to, or, but I, as a commission, you probably want to have your own voice and just ask your own questions. So that's what is anticipated. Interpreters, people can have interpreters there. Again, you can compel appearance, failures to appear. When either the complainant or subject officer fails to appear, the investigative panel may receive statement from other persons or those present and rely on that information to make your finding. So if an officer refuses to appear and all you have is the complainant testify as to what happened, and if all you have is a one-sided story, you can decide, the case in that respect. Again,
what is the remedy if someone lies under oath?
Well, okay, if this is a quasi-judicial proceeding, if you know that the person lied on, and this is why the penal code says that complaints have to be submitted under penalty of perjury. No lying. If somebody lies in a quasi-judicial proceeding that has legal ramifications, they suffer the consequences. It's you've committed perjury. Now it would be up to the commission to bring that matter forward or to try to press it. And that could be on behalf of a police officer or somebody else who testifies. You can't lie. It's a quasi-judicial proceeding. So there's a remedy. There is a civil procedure that the CPP would have to file in the Superior Court to say that this person perjured themselves. I don't know that would ever happen.
I'm just curious, yeah. And so,
yeah, but there is a judicial remedy, but it's a bit convoluted. So.
Okay, and is this a good, scroll down just a little bit to see, oh, we're at the end. So that is a good stopping point.
That's it.
So perfect. And it's 1:30 and you've gone through the entire document. And so Dwayne, if you can spend your vacation cleaning it up.
I will. I'm going to clean it up. I've been making notes contemporaneously. So what I do is I'll clean it up and make sure I have it back to you all before, and then you have at it. So what I did, just so I understand, I took out the questions regarding the 5 commissioners. It looks like that's a good number. I did change the quorum language as Chair suggested, as Brandon suggested. You all take a look at that and see what you want, but I think I've made the changes that have been requested. The one thing I can say is when we first started this, we talked about complaints, if you all remember, and we were talking about complaints under penalty of perjury, et cetera, because, and I've sent information to you all in terms of what the penal code requires in terms of complaints being filed. But just not to be specific, I just suggest, and you'll see it in this document, that the complaint, where it talks about complaints by citizens, my language, it's a suggested language, it just says that complaints must be filed, consistent with the law, with legal requirements, et cetera. And then I think we need to leave it at that, because the law is a law in terms of what constitutes an appropriate citizen complaint. So, I mean, that would cover it. And you wouldn't have to specifically say that you have to do this under penalty of perjury, but that is what the law requires. So you'll see that. I will get this back to Robin, Alina, Charmaine, and you all can see what you think.
Okay, and so we will recommence that after you return from your vacation, so in September. And then for next week, we can talk about the timeline that I submitted. That probably will take a while to go through. And anything else for next week's agenda? Okay, and so Patrick, this is your last time. You're welcome. This is a public meeting, so you're welcome to come back anytime. But we've appreciated your thoughtful and helpful questions. And seriously, if there's anything throughout the process that you want to communicate, you can either do it through the public comment process, but you also can email me or Brandon with whatever issue you want to raise. And so thank you for your service, and I think we're done for the day. So everybody have a good weekend.